Mr. Gohmert.
Thank you, Mr. Chairman. Mr. Adams, were you hearing the last answer? Do you have a response to the statements by the last witness?
Couple. First of all, there is no question that the 15th Amendment has limits. The Supreme Court made that very clear in Shelby. There has to be a high showing by Congress. The things that are in H.R. 1, I can assure you, are not going to be viewed favorably by particularly this Supreme Court, because they go way beyond what even Section 5 was. I mean, deciding that you have X amount of days of early voting, that doesn't have anything to do with racial discrimination, absent some high showing in Congress, which we haven't seen. Now, the Elections Clause is different. My written testimony goes into great detail about that this Congress should exercise that power as a last resort. A last resort is the term that was used by Alexander Hamilton. It was set up to preserve the federal government, not to mandate 30 days of early voting around the country.
And with regard to the allegation that these constitutional claims are often raised to try to defeat civil rights actions, I will always go back to the Constitution. That's our foundational document to see if anything, no matter whether it's Republican or Democrat, whoever is bringing a bill, does it meet constitutional muster? So I would hope that that's where we always go back to. And so when we seek to take the power away from the states in the 14th Amendment that says states, it's up to the states. They can exclude anyone who's participated in rebellion or other crime. I mean, you need a constitutional amendment to seize that power away from the states to make that determination. And I am impressed by a political party that thinks their power will come from people who have committed felonies and maybe are here illegally, don't speak the language that most do. At least 80% is a primary language. That's interesting politically, but here we're guided by the Constitution. And I want to go back to the Voting Rights Act. I was accused of being against the Voting Rights Act when I made very clear I had an amendment that would force the pre-clearance requirement on any area in the country that had a certain level of racial disparity. But Mr. Sensenbrenner and Mr. Conyers said, nope, we want to keep punishing. In effect, what their action said, we want to keep punishing children, grandchildren, and great-grandchildren for the sins of the original person back over 50 years ago. And we want to keep that standard for 50 more years. We want to just keep punishing sins of long-gone people. And that's not supposed to be what America is. And so when we had the information that clearly showed that states had improved and they were doing a better job than a district in Wisconsin, a district in Massachusetts, a district in California, why wouldn't we apply those pre-clearance requirements to any district where there was racial disparity? And I got much more consideration from Mr. Conyers on that issue than Mr. Sensenbrenner. Mr. Conyers, I said, look, I have, and this was outside the hearing, I've talked to deans of different law schools, liberal and conservative, and they all say, you can't keep punishing people for sins of far gone others. You have got to punish sins that are current. And you've got to change that or the Supreme Court's going to strike that down. And Mr. Conyers said, you make a good point. Let me talk to our folks. And he ultimately came back and said, you got a good point, but it's already passed, so let's just see what the court said. Well, the court said what I was told by liberals and conservative deans alike. It's not going to stand scrutiny by the Supreme Court. It didn't. So I would hope we don't try to go back to that. If we're going to punish racial disparity, let's go where the problem is, and some arise in the future, as they have. But let's go to those districts and punish those by pre-clearance requirements, but not keep punishing people 50 years after they've corrected their actions. So I'm hoping that when the Voting Rights Act comes up, we will look to be more constitutional than the last slam dunk on others was. And I see my time's expired. I yield back.
Thank you, gentlemen.